Hello and welcome to this week's version of Foreclosure Stories. My name is Dan McGookey and I'm proud to bring you these videotapes every week regarding actual cases that I've had regarding people struggling to save their homes against highly predatory mortgages. This week's story is what I've called the peeling away the layers of the onion, and it's the story of Max. Max's case is a situation where a foreclosure was filed against him some time ago, and in fact the bank proceeded to file a motion for summary judgment. What that is that the bank argues that based upon an affidavit from someone from some part of the country, they come forward to say, we know what we're talking about, and judge, this case is ridiculous, there's no reason to let it go to trial, you should grant us a judgment forthwith because this is a waste of everybody's time. That's to paraphrase the essence of these motions for summary judgment. Under the rules of court, it is required that an affidavit be signed by a proper party to support the summary judgment, and thus, as I indicated, there's always somebody out there that these banks can come up with to sign an affidavit saying essentially that they've got knowledge about what they're saying. The reason I call this story peeling away the layers of the onion is because, at least in Ohio, the courts have been willing now in recent years to look behind the scenes of these affidavits and determine, beyond the generic self-serving language of the affidavit, the courts are asking things like, is this person really qualified to say what he or she is saying? Do they really know what they're talking about? One specific question I know that in a case that the Ohio courts have ruled in reversing a foreclosure judgment is that the affidavit never said that he actually viewed the original note. And the bank's ability to prove that they have the original note is critical in the eyes of the law, in that it's, generally speaking anyway, it is the holder of the original signed promissory note, not a duplicate copy, not a reproduced copy, not the kind of copy that you get off a copying machine, but the actual original signed note the day the loan was taken out. The foreclosing party has got to be able to prove, and the burden of proof is on the bank, to show that it has physical possession of the original signed note. And generally, without that, then the foreclosure cannot be ordered. So the point of this week's story, everyone, is that you need to press your bank on this issue of whether in fact they have the original note. And in turn, what that often means in my practice, I've determined, is that that you have to ask questions like, where did this document that they claim to be the original note, which a lot of times the banks will come forth with a document that looks like an original, but may not be an original. So then you have to peel away the layers of the onion and ask, where did that document come from? Where was it kept? Who's got custody of it? And these are the right questions to ask, because generally the bank representative has no idea what the answers are. And in turn, the bank cannot be granted a judgment, foreclosure judgment, on that kind of evidence. So thank you for tuning in, and please come back the next time for next week's version of Foreclosure Stories. Thank you.